When you're wrong, you're wrong. And if you make a bad decision, don't care if you're behind the shield or just a citizen on the street, you have to live by that decision.
That is the mayor of North Charleston, South Carolina, Keith Summy, condemning the fatal police shooting of Walter Scott. Welcome back to America's Forum with Miranda Kahn, J.D. Hayworth. And Miranda, Officer Michael Slager has been fired from the force and now faces murder charges after video surfaced of exactly what took place.
Yeah, and that video shows Slager firing 8 shots into Scott's back as he attempted to flee. And while some say the video clearly shows what happened, others are raising concerns about whether that video will be enough for a conviction.
Joining us now for an in-depth legal analysis, criminal defense attorney Geoffrey G. Nathan, who is on the telephone from Boston, and of course still with us from Newsmax Washington, my old congressional colleague, former Pennsylvania Congressman Bob Walker. Geoffrey, we thank you for your time this morning. If you were defending the police officer, what do you do after everyone sees this video?
Suppress it. File a motion that says this was a concocted video and no one can rely upon it, and therefore the judge should exclude it from evidence. That's one way you go about it. And even if the motion is denied and the video comes in, you use it to your benefit. You say, you see what that guy did? He deserves every bullet that he got. He put that officer in fear of his safety. And you go forward and you see what sticks.
But isn't it also true that the officer, even if you suppressed all of that, that the officer really did make a huge mistake in basically shooting to kill a guy who was running away from him?
Well, you know, the shoot to kill is obviously a risky defense strategy, but, you know, there's always two sides to a story, and we don't have the assault on the officer on video, so we don't know really what transpired in the beginning. This is a defendant who has a history of assault. He's got warrants out. I mean, you know, law enforcement got a pretty tough job. So when we're defending law enforcement in the use of excessive force, you got to attack the decedent and say that the decedent was the perpetrator of the crime and the law enforcement acted reasonably in self-defense. And most of the times it works. Whether or not it'll work in this case remains to be seen, however.
Geoffrey, some have been questioning whether or not the police department acted too quickly, rushed to judgment. Despite seeing that video, as you mentioned, we don't know what transpired prior to that video being shot or what happened afterwards. Because there's been speculation about CPR, that they had called to have someone, paramedics come out and do CPR on the victim, but you don't see that in the video, and the witness says he didn't see that. So
well, you see, what we don't know and what we don't see is whether or not the decedent in this case was running to go pick up a firearm, could have bent down, picked it up, and turned around and fired at the officer. So whether or not we sit here and pick apart what the officer was thinking or not, the real job comes about and says, how are you going to defend this law enforcement official? And where you defend him is to say, these are the reasons that he was in fear. Criminals do plant firearms for use later on in the commission of their crime, and so here you have someone who's stopped for a minor infraction, a taillight, who gets out and runs. I mean, you know, something's a further crime is afoot in that circumstance. So,
go ahead, Geoffrey.
Yeah. So his actions, from a defense perspective, to put the guy down, were reasonable from a defense perspective.
Geoffrey, 30 seconds left. If you were defending this police officer, now former police officer, would you move for a change of venue, or is this video so gone viral, so proliferated society that it's impossible for this guy to get a fair hearing?
Well, the change of venue thing's going to be played out at a later time. I'm not so certain that I would move for change of venue right away. You probably have to have a little more. However, there's no question doing it right in his own backyard is going to be really tough, especially where the chief of police is ragging on him and saying that he belongs in jail for the rest of his life or executed. So you may have something on that basis separate and apart from the video.
Well, Geoffrey, as you come to us this morning from Boston, obviously there is major news there with the Boston bomber found guilty on all counts. And now the question becomes, will that Boston bomber face the death penalty? When we come back, the legal perspective of Geoffrey Nathan and more with Bob Walker. It's all ahead here on America's.
We just, as a group, we wanted to come out and say thank you to everyone who's worked so hard to make this happen. We're obviously grateful for the outcome today. It's not a happy occasion, but it's something that we can put, one more step behind us.
The reaction of a Boston bombing survivor speaking out following the jury rendering a verdict in the case of Dzhokhar Tsarnaev. Back now on America's Forum alongside Miranda Khan, J.D. Hayworth, and rejoining us to continue our conversation on the telephone from Boston, it's noted criminal defense attorney Geoffrey G. Nathan, and from Newsmax Washington, former Congressman Bob Walker. So, Geoffrey, Tsarnaev found guilty on all 30 counts. The question is the death penalty. Will that end up being his sentence?
No. The reason is jurors in the United States District Court are loath to impose the death penalty. Some of them probably are thinking it makes it too easy on them. Some others, even though this is a death penalty qualified jury, are going to say, I just can't do it. I think that he was under the undue influence of his brother, and we're not so confident. We think he's guilty, but we don't know if he's guilty beyond a reasonable doubt enough to kill him, and I think you're going to have problems getting a unanimous verdict to execute him. It's probably not going to happen.
Even though this appears to be a classic case of premeditated murder, this doesn't enter into the judgment of the jurors, you don't believe?
Well, premeditated is one aspect of it. The issue is whether or not there are any mitigating circumstances. That's what the defense strategy has been all along, to plant the seeds in the minds of the jurors that there are mitigating circumstances which outweigh the aggravating factors, and when you balance the equities, come out on the side of the mitigating factors, his youth, the fact that he's an immigrant to the United States, the fact that he probably only thought that these pressure cooker bombs was going to scare people. He didn't think they would kill and maim. I mean, there's a whole host of factors that go into consideration when you're making a homemade bomb like that. You really don't know what's going to happen when you set it off because you don't have any experience in testing it. So juxtaposed with, say, the Tim McVeigh, where he put enough explosives into the back of a large U-Haul truck, you know you're going to kill people. But you take a little pressure cooker and manufacture a bomb somewhere, they don't even know where it was made, you don't know what the end result is going to be. So I suspect someone's going to say that Tsarnaev only intended to scare people, and for that reason, the jury should give him a pass and let him go spend some time in a prison cell. If it's the whole rest of his life, then it's the whole rest of his life. But to execute him because you think he intended to kill people, when you really don't know for sure, I don't know. I don't think it's going to happen. Nope.
So if you were defending him, Geoffrey, what would be your next step?
Well, the next step is to have him engage in a discussion with the probation department so that a pre-sentence report can be prepared for Judge O'Toole to read. That would give him some background. And then you prepare him for his testimony where he's going to ask the jurors for his life. Now, what kind of a life is he going to have? A life in a tiny cell with absolutely no contact with human beings. That's an incredible punishment. I mean, I've dealt with clients that have been in solitary confinement for periods of months, and they start to lose their mind. So, any of our audience who thinks that Tsarnaev's going to have it easy if he doesn't get the needle, got to put the thinking cap back on, because it's a real tough suggestion to say that he's going to have an enjoyable life in prison. When I say no contact with human beings, I mean none. Okay?
Well, we will see what punishment is handed down, but Geoffrey Nathan, we do appreciate, as always, your perspective as criminal defense attorney on these two very important cases. Thanks so much.
You got it. Talk to you later.
Now, when we come back, Bob Walker and I were in Congress when we passed welfare reform. But there's a state legislator out in Missouri who's got his own brand of food stamp reform he's advocating, and he will join us next here on America's Forum.